A good evening once again and welcome to the show that has become one of your favorite shows, The Law and You. One Accord TV, One Accord YouTube, One Accord Facebook page. Karibu sana. We discuss different discussions. We have had amazing discussions with different lawyers, advocates. And tonight we have a very seasoned advocate, 13 years in practice, one of the best employment advocates in town. Ladies and gentlemen, help me welcome our guest today, Rose. Please tell us your full names, and then from there we can be able to continue with the discussion.
All right. My name's Rose Kariuki Owesi.
Rose Kariuki Owesi.
Yes.
Karibu sana. This is a show, One Accord. We inform people, we learn, we discuss. You are free to use your legal jargon, your Swahili, your Kizungu, all of them. Let us interest. Today we want to talk something about employment issues. And you know, the biggest challenge that we have been having on employment is livelihood of people. And when you touch on that, you touch on the well-being of people. And one thing we have been talking about employment is what are the things to look at when it comes to employment and the law. Because unajua kitambo ilikuwa ile you wake up one morning, you employ someone, tomorrow it goes. And in the show we have been having different discussions. And tonight we'd like to have a discussion that will help the employers. I think I felt like we've been leaning so much on the side of the employee. Employer atafanya aje kusaidika, kupelekana kotini, kufanya hivi. But we have not had that time even to look at what are the steps can an employer do to be able to safeguard himself, for lack of a better word. Because I think everyone lives in a defense mechanism. What are the things that would you say are the challenges that we're having today when it comes to the employee-employer relationships?
The biggest challenge employee-employer relationships have is the feeling of, from the side of the employer, of being stuck with an employee who is neither not meeting your standards or the relationship has been not very good. And so you feel stuck as an employer on what do you do with this employee and how do you get them to leave the organization?
How do you get rid of them?
How do you get rid of them? Yes. That has been the biggest challenge with the employers. Yes.
Because, and why do you think Parliament, in their wisdom or lack of it, that's what I think lawyers say, thought that you are supposed to be stuck with one person? Because I don't understand. We were having a discussion last Tuesday with one of the wakilis, and we were talking about divorce on consent, and we were saying, and we discovered you cannot leave marriage, you can enter. And are you saying it's the same thing, that you can enter employment relationship as an employee? Leaving is the problem.
Yes. The advantage with an employer-employee relationship, you have room to maneuver. There's a grace period for you to maneuver. Unlike a marriage, once you're stuck from day one of giving your vows, from day two you have to have good reasons as to why you have to leave. For an employee-employer relationship, you have room to maneuver, to test your relationship, to test your working ethics, to test your jailability. Yes, so you have that room.
You can plan your exit.
You can plan your exit.
And that is what I want us to speak about today.
Yes.
For example, if I'm an employer, what are my options? What am I required to be able to plan my exit? But before we reach there, what are the reasons the law allows you, or how does the law allow you to exit each other?
The law gives you a process for exit, the same way it gives you a process for entry. So that when you enter, there is as you form that relationship, there is that which gives you the terms and conditions on how you're going to run the relationship. And that document is what we'd call a contract of employment. So it needs to handle if there is a probation period, how long this contract should take, what are the roles of this employee, and if there was to be exit, what would help the employer get to an exit.
So wakili, what you are saying and what you are telling employers, tuache kuandikana kwa barabara.
Yes.
Let us have a paperwork, a very clear contract, one saying who are you employing, what position, what are their roles in this place? Will they be doing 1, 2, 3, 4, 5? What will be the mistakes that will be considered if you do this to Tachana?
Yes.
And what is your benefit also? Because, you know, sometimes as employees, you are stuck with one employer even for 10, 20 years. And you don't have any benefits. And you just wake up one morning and you leave just like that. So I think the first thing that we need to speak, maybe I don't think today we'll speak about it, but it's the issue of the contract. And maybe my advice, as usually say in this show, tafadhali enda ona wakili, ulipo wakili, akutengenezee contract mzuri. And the biggest challenge I think we have with people is people do copy and paste. So because nilipatiwa na huyu wakili contract, you go employ someone, copy and paste, and you enter yourself into problems. You talked about, yes, you have talked about, now we have reached a point where I'm lucky I got a good contract, I have everything. What are the instances that I'm allowed to exit? Or what are the different types, or what are the different ways that we can exit and stop a relationship as an employer-employee? All
right. There are 4 instances that you can terminate an employment contract. Number 1 is when there is what we call termination based on gross misconduct.
Gross misconduct, yes.
Yes, and gross misconduct is already highlighted on what can amount to gross misconduct under the Employment Act.
Yeah.
Majorly is if, let's say, you've given instructions that they fail to be honored or to be executed. That can be termed as gross misconduct because this employee has refused to adhere to instructions given.
Yeah.
Most importantly is that once you're engaging your employees, have something in writing.
Yeah.
So that as you get to give them reasons as to why you're terminating their contract, you have a record on how this relationship has been. If there is something that they were told to do and they did not do it, then it's in writing, you can refer to it.
Yeah.
Yes.
So what you're saying, one is on gross misconduct,
yes.
and the reason why I'm following up on this, I know these are fight or fight today, but the biggest issue you're having is the Gen Z. There are jokes going around that they will come and tell you, "Misifanyi yo." So that's a ground of gross misconduct, that today you have been given clear instructions by your boss and you have refused to do.
Yes.
And I don't know, in the past was that problem or it's a Gen Z problem? Maybe that's, this is not legal, just thoughts, because every time I talk to people, that's the biggest challenge they're asking. What is wrong with this? Some people think I'm Gen Z, so at least
you look young.
I look young. But is it a problem that has been there, especially on the issue of human resource and the Gen Z issues?
Yes, it's a major issue,
yeah.
Especially in the relationship between an employer and an employee.
Yeah.
The only thing is that maybe most of them are not documented.
Okay.
Yes, but now with the enrichment of the law, yeah, and people getting to know more about their rights, they get to push and to bring it to the limelight. And so yes, now it's easier to interact with many cases of gross misconduct being documented, and therefore by the time the employee is getting to be terminated, then they have knowledge on why they are being terminated.
So one thing we need to advise our, because remember today our show we are more of the employer side, Mdosi. So one thing you are saying is have files for your employees, as in if you have told them do this and they have not done, document that. You went and you warned them first time, second time, that time I called you, even you wrote an apology, put it there. So that by the time you are coming, you are showing, even if someone takes you to court, you are showing the court, I did not wake up one morning and decided, oh, don't work with this person. Yeah, this person has become difficult, yes. So maybe that was the first one on gross misconduct. What about the second one?
As you get to the first one, which also builds up to major instances of termination, as you terminate, you have to observe two things, the process that you undertake and the reason.
Yeah.
So gross misconduct, having many other subheadings under it, you have to ensure that it falls under the reasons. The reasons that you've given this employee for termination is valid.
And this is why even summary dismissal comes in place.
Yes.
That's now the decision at the end.
Yes.
So yes, there's something that we have been talking whenever we talk about employment issues. The process needs to be clear.
Yes.
And the reason needs to be valid. So that if you have a good reason of why you need to fire me, but you don't do the process right, it's a problem.
Yes.
Do you want us to talk about the process now or later, Wakili? Do you want to talk about it now?
We can talk about it now.
Yes. So when now maybe you have come, ile file yangu imeshika vizuri nini. What is the process? Because I think that's the biggest challenge. Because at that moment nimekasirika. In fact, where is the law telling me to wait and have this process? And mimi ndio mdosi, toka nje uende. And no usirudi kwa hiyo ofisi tena. So that's what the court is saying. Do not do that. That's what the law says. Do not do that. So what? Yes, we have a good reason. File yako imejaa vizuri. So that's the reason. You have a good reason why you are firing. Kwa ile contract imeonyesha ukifanya 1, 2, 3, 4, that will be gross misconduct. What's the process I will be talking about?
The process is the process of giving this employee a chance for a hearing.
Yeah.
And this chance can either be through an oral hearing or in writing.
Yeah.
So you find yourself as doing what you call notice to show cause.
Yeah.
That can be a process for termination.
Yeah.
That you give this person a chance to put in writing why did they do 1, 2, 3, 4.
Yeah.
And then they'll be given a chance to respond.
Yeah.
The other process you can also do as part of the hearing is to call this person for a meeting.
Yeah.
And tell them, please come for a meeting on this and this day to discuss 1, 2, 3, 4. Then they will come and give their reasons for it. That would be a process. The process is to ensure that you have done it fairly, and fairness is in giving them a chance to be heard.
A chance to be heard.
Yes.
And then after that, you can make your decision now.
Yes.
And then one thing that people need to do, we have talked this several times in depth. The moment when you're giving the notice to show cause, you need to say the mistake there inside. You don't tell them, I think you have done a problem. Should I fire you? You need to say on this date and this date you did 1, 2, 3, 4, 5. And because of this, I want to fire you. For them to explain themselves. And I've been saying the biggest challenge we're having is that the moment someone sees a notice to show cause, he feels he's fired. But ideally, the notice was supposed to be, if you reply satisfactory, we continue shake hands, no hard feelings, and we move on. But the biggest challenge we have now is the HR people. By the time he's showing you that, in fact, the summary dismissal letter is ready, just waiting for that. So yes, what's the second thing that we can terminate our relationship?
It can be on the expiry of the contract.
Okay.
Yes, so that you can give an employee a contract which has a duration.
See, permanent and pensionable.
Not permanent and pensionable.
Yes.
Whereas, let's say it's for 1 year, it's for 6 months, and this 6 months lapse and you feel you do not want to renew that contract, that would be a valid way of terminating that contract.
Yes, so that's another option where the relationship can stop.
Yes.
And the third one will be?
If you're undergoing what we'd call liquidation.
Yeah.
Yes. That would be a reason to terminate a contract.
Yeah.
But for that also there's a process. You need to notify the labor office, and you need to also give enough notice to the employees.
Yeah.
Yes, for them to know that their livelihoods is being interfered with.
What people call so much redundancy.
Yes. Yes, there's redundancy and the company continues, but there's also the part that
liquidation the country is going under.
Yes.
Okay.
Yes.
So I think that's thank you for the clarification. The issue about redundancy and liquidation is different. Liquidation is the company is closing.
Yes.
So because if I'm closing, I cannot employ you.
Yes.
But redundancy, we are saying the company has 10 people, but if I'm left with 5, I will be able to survive. So and the law has a process of how you need to terminate these 5. You should not wake up one morning and decide you and you and you and you leave. Because if you do it wrongly, also the law will punish you again.
Yes.
So I think the biggest thing about as an employer now is for you to be able to check on these things and be able to ensure that you tick all these boxes nicely. Which other one now is that?
The fourth one is when the employee themselves want to exit the company. And at that, the law is not very serious with it. They can just give notice and leave according to their contract.
So what you are saying, Wakili, when we enter this relationship called employment with my employee, me, I cannot leave him. But he can wake up one morning and tell me next month, adios.
Yes. But depending on the contract that you entered into and the notice period given to each other that is needed to be given, then if they do not adhere to that notice, then they should also compensate you.
They can compensate us.
Yes.
But now the question, in fact, no. The thing is this, for example, even as a Mdosi, can I come and tell you, hey, I want to give you 1 month notice to leave my work?
No. As an employee, no. As an employer, no.
But as an employer, I can tell you, hey, in the next 1 month, I'm okay to go.
Yes.
Wow. So what you're saying is for us as employers, we are stuck.
You're stuck, but the law has given you a chance on the probation period.
No, but now maybe I've worked with someone for 3-5 years. They have not done any mistake, but I just don't like their blood. Damu yetu wazisikizani, all of a sudden.
Azizi kwa hazijasikizana for those 3 years.
Wakenya wanakuwa na hiyo damu isikizani.
Damu ingekosa kusikizana the first period of probation, hiyo ungeachana. But ikikuja kukosa kusikizana hapo katikati, you have to have a reason.
You have to have a reason.
Sababu pia haiwezi kuwa mliamka tu leo kaamua damu imekosa.
Lakini yeye damu yake ikataa kusikizana, mimi anaweza toka aende.
Yeah, anaweza toka aende.
So I think, is it, maybe now these are just a personal opinion, is it something you think we need to have, like, what do we call it? Where we need to have reforms on that damu ya employer pia ikataka kusikizana na mtu anaweza mwambia enda.
I think the part we need to really critically look at is on the period that the law had provided for a 13-month period. Because if you're in an employer-employee relationship and you've stuck with each other for 1 year, then you know how each other works and you're able to gel, and then you can push for another 10 years, 15 years. But 1 year is usually a lot of learning each other. So that is the part that the law needs to be considerate on, and which the courts over time have made decisions on it. Because we'll see that under the Employment Act, specifically section 45(3), it had provided a provision that if an employee has been in employment for 13 months, then they cannot sue for unlawful termination. Because you'll find that is the period when you're on probation, it's been extended. A lot of things happened in the first year. So with that, if the law can gel the relationship on that aspect, then yes, you would have a chance to leave. But with that, again, our recent Court of Appeal decision has also provided that even if this employee is on probation, you still have to give them reasons for termination.
Yes, I think today I wanted us to discuss about that because one of the reasons, you remember now we had four, five, in fact, it's 5 reasons now you can terminate the relationship. One, you have said it is the issue of gross misconduct, whereby someone has done a mistake and you need to, the process needs to be right. The process and the reason need to be right. The second one, you had talked about if you are going on liquidation, if the company is going under, but you need to inform, there's like a process, you need to inform the labor office and inform the employee. The third one was the issue of redundancy. If maybe you need to restructure yourself, especially with the economic meltdown and everything, but also you need to have a process of redundancy, informing the employment guys, ministry, the labor guys, and also the employees, and be able to have. There's the other one where we were talking about the contract has come to an end. Maybe we have the contract was 1 year, 2 years, or 3 years, 1 year, 2 years, or 3 years, and it has ended. That's another reason why you can be able to terminate. Then there's the other reason where we were talking about the question I wanted to ask: do we have a provision whereby the employer and the employee can come sit down and have a situation whereby, do you know what they call it? Mutual separation, yes. By consent, separation by consent, yes. Or employment contract. Is that possible? It
is possible, and it falls under the fourth option that we've given, where the employee can decide to leave. In that option, it can be that your relationship has really been severed, and so you opt to agree to leave.
Agree to leave.
Yes, and if you both agree to leave, then you can come into an agreement, put it in writing on how you're going to separate.
On the things, maybe I will give you this, you'll do this, yes, and everything.
Yes.
The other thing now, there's something you talked about, probation. How can that help the employer? And are you not advising the employers to have these permanent and pensionable contracts? I will not call them contracts, agreements.
Agreements. Permanent and pensionable also works for the employer in the long run, because you have stability in terms of turnover. But also, for you, before you make that decision of permanent and pensionable, you have some leeway to determine if you need this person for the long haul, or you need to terminate the relationship early enough. And that period you've been given is at least 1 year. Because you have the option of having a probation period of 6 months, which can be renewed by another further 6 months.
6 months, yeah.
Yes, but you cannot renew it further.
After that, you have to make a decision now.
Yes.
You can, and after that, can you give a contract for 6 months, or you have to give a contract for 1 year?
As long as you people agree, it's okay.
You can give.
You can come down to.
And can I give a contract for 1 year today? Then tomorrow, when we are done with 1 year, I can give you for 3 months, then 6 months, like that.
Yes.
As long as we are agreeing, and the other contract has come to an end.
Yes.
The other thing people ask a lot is, if I've employed someone and they are pregnant, and they will not be able to work, is that a reason why we can now separate?
No.
Because they are not able to work. I don't know, they will not work for 3 months.
No.
And I need to employ someone else. I don't have money for that person.
Unfortunately, terminating someone during the pregnancy is termed as discriminatory. Because pregnancy is bringing life. And it can come with a lot of complications. So you need, as an employer, to be considerate. Otherwise, if you use termination, you use pregnancy as a reason to terminate, and an unavailability because of pregnancy as a reason to terminate, then it can be held to be discriminatory on the part of the employer.
So what you are saying is that that cannot be a reason.
It cannot be a reason. You have leeway to even issue, if you think they have stretched a lot of their leave days, you have leeway to even give them unpaid leave, let them finish their maternity or their pregnancy and come back.
So after the 3 months maternity, maybe there's complication, the sick leave has ended, it's usually 30, 45 days has ended, the paid one, you can even extend them to another 2 months or 3 months unpaid.
Yes.
But do not terminate.
Do not terminate, especially during pregnancy.
During pregnancy.
Yes. Remember, pregnancy is only for 9 months. Yes.
What else can you tell, maybe if an employee is seated and is listening and is confused about the wage bill, what can you tell them? What may be other things they need to look out for? The
minimum wage. The minimum wage is gazetted periodically as the lawmakers make their decision. What is the minimum wage? So keep updating yourself. The minimum wage gives you the bare minimum, and it does not provide for you a ceiling. So you can go as high as you want, but at least observe the minimum wage. And it also provides which categories of employees.
Which categories of employees?
Yes,
are house girls part of that?
Yes.
And what's maybe the last time you checked the minimum wage of house girls?
I believe it was something to do per day. It was, I think, 600, if I'm not wrong.
Because it goes all the way per month to 14, 15, 16, 17,000.
Yes.
And also they have a minimum wage of Nairobi and upcountry. And Ruiru and Kiambu and Machakos. So what we are telling our viewers, tafadhali, and you are employing a house girl, plus minus around 15,000 should be the minimum you are supposed to be paying.
Yes, the advantages they have is that when they observe the minimum wage, it also caters for house allowance.
For house allowance.
Yes.
And
so it
covers all of those.
Yes.
So I think this is something that, and you know, I've been telling people on this show, this is the emerging trends, and we have a lot of cases you can discuss whereby house girls went to court and they were given $1 million, $2 million because of the minimum wage. Someone worked for someone, I think, for 10, 15 years, zikahesabiwa, zikabakdatiwa, and all of them, they came. And yes, and you talked about the Court of Appeal decision that spoke about even during probation periods, you need to give reason. Because kitambo probation ulikuwa unaamka unaambia mtu enda, we are 3 months probation to end. Why did the court feel fit to do this?
There has been a confusion in terms of decisions from the High Court, in that we had a decision by Justice Lenaola that had provided that Section 45(3) was unconstitutional. And then we had another decision by the Court of Appeal that had said the employment court is not bound by Lenaola's decision because there were courts of
equal jurisdiction.
Jurisdiction. So you would find that some courts would say then you're not supposed to give them a hearing, but other courts are saying you can give them a hearing. So this court, the Court of Appeal decision, which is a recent decision in July, I believe that was February this year, said that even if the person is on probation, then they need to be given reasons. They need to be taken through the hearing process.
Need to be given.
Yes.
Ladies and gentlemen, let us understand this. Even during probation, the procedure and the reason should be right. Otherwise, wait for the 3 months for probation and refuse to. In fact, there's a court decision I wish I remembered, and it was saying you are better off waiting and not give a reason. Just saying, hi, the 3 months are ended, we will not be maintaining you. Because if you go to explain, they have ended, but I remember you are coming late, you have to prove that process, how you came to that process of the reasoning that came. And one thing also I would like maybe to tell our viewers, you are an employer, please get a qualified and a registered HR person to do these things for you. It's more expensive when you go out of this. Get an advocate in your panel, get someone to help you through these processes. It becomes very expensive because like now we are talking about, recently we had a case whereby people are told to pay almost $1 million shilling. And this was something they were paying 50,000 because of pregnancy issues. And in fact, the court was lenient because you have seen courts that even say pay 2.7 million, 2.5 million if you fire someone on pregnancy. Someone was even fired 7 months after reporting back to work, and they were told, can you pay them 2.5, 2.7 million? So I think those are some of the things that we need to be able to check, especially by employers. But one thing I've come from out of today is that if you're an employer, please have your contracts, file your staff out properly, follow the processes. The law, quote unquote, is against the employer because the law feels you're the one who is powerful in this relationship. Yes. So because of that, you need to be more careful. You need to document your leave days. Because there are some people who give leave and they don't document it. So mtu anakuja siku moja anasema uje nipatia leave for the last 5 years. Na lazima umlipe hiyo pesa. Public holiday, you're the one who is supposed to show that on this day mtu alienda leave, on this day alienda, and you're the one supposed to set those records. I don't know, Akili, if there's something else maybe you would wish to tell them before we close for tonight.
Employer-employee relationships are about livelihoods. Yeah. The same way the employee puts their energy on the business to ensure that it continues running, they put their lives into that business the same way you put life into their lives by paying them the salaries and ensuring that the processes in your institution are fair and cater into their needs. Yes.
Asante sana, Wakili Rose Kariuki Owesu, for your time. And I hope this has been a moment of learning for employers to be able to understand the processes of how the relationship between you and your employee should run and how you should even terminate these processes. And for you to be able to learn that you need to have contracts, maybe 1 year, the 6 months probation period, the 3 months probation period. And even if you are mad, in fact, one thing I suggest is sometimes you can tell someone just go on leave, come back on Monday, I will talk to you when I've breathed in and out. It's been the law and you. Kenneth K. Mbaabu from Mbaabu Advocates. May God bless you. Good night and see you on next year.